In order to obtain guardianship over someone in the state of Indiana, first you start with a petition. If you have a child that's under the age of 18, or you have an adult, maybe that has special needs, or is having Alzheimer's, dementia, or some other health issues that are causing that person to become incapacitated, then you can file a petition for guardianship with the court. Really, even before you file your guardianship, it's important to have a few things figured out. If I'm trying to get a guardianship over a child, do I need the biological parents' consent? If it's an adult, we want to make sure that we get a physician's report, or we're talking to the physician to see if a determination has been made with respect to incapacity. So there's a lot of things that you want to do prior to your hearing on your guardianship case. Well, a few things the court's going to consider is, one, do we have an incapacitated individual? Again, with a child, that's easy. Age is considered incapacity if they're under the age of 18. Have you been providing care for this individual? Are you a close family member, or if you're a friend? Well, if you're a friend, do you have the family member's consent? And what is it in the best interest of that individual to have a guardianship appointed over them? A lawyer can help your guardianship case by guiding you through the process. Again, there's a lot of factors to consider. Do you need a guardianship over the estate, or over the person, or both? Is it a contested guardianship? What do I need to be prepared for? So there's a lot of questions and guidance I think is necessary during the guardianship process. If you find yourself in a situation that you have a child that's in need of a guardianship, and the child's not yours, it is possible to get guardianship. We see that a lot with grandparents or siblings, where for whatever reasons the biological parents can no longer provide care for that child. If you can get the consent of those parents, that's one way of getting a guardianship. There may be a Department of Child Services case that's open. We need to file the guardianship. We need to allege why the parents can't provide for the care. Ideally, hopefully the parents consent, but if they don't, then you need to be prepared to go forward with the hearing and argue your case as to why the children are in need of guardianship. If you find yourself in a situation where you have a special needs child that maybe is turning 18 years of age, or you have a loved one, a parent that's got Alzheimer's, dementia, maybe suffering from a stroke, you file a petition with the court. Make sure you have evidence with respect to the incapacity so you can establish that with the court. If you have an emergency situation, the courts are great at getting you in. I've had some resolved within 2 weeks. I've had some 30 days. But I would say, in general, in a guardianship case, if we don't have an emergency, we're probably looking at a couple months to get through that process. What a lot of people don't realize is just because you're legal guardian doesn't necessarily mean that you're the one making decisions about the person, or necessarily making decisions about their finances. So there's a guardianship over the estate, which means you're able to make decisions over that person's finances, over their assets, and a guardianship over the person, meaning you're going to be making decisions on their behalf. And if you don't ask for the right one, you're not going to get the authority to do that. So it's important to determine what type of guardianship that you're trying to go after, what authority and power you'll need to make sure that you make the appropriate request for the court.